What is the most common mistake made by business owners during the early phases of their company's growth and development? Making the blunder of not establishing a strong legal framework as soon as possible. However, while it can be tempting to plunge headfirst into your company's vision and begin making your idea into a reality, business owners must take a step back to ensure that their legal bases are covered. Here, we've made a list of the 7 most essential legal documents that startup founders should put in place to avoid potentially expensive legal issues down the road. Articles of Incorporation. One of the most common mistakes that business owners make is failing to create an appropriate corporate structure from the outset of their operations. Even with the formation of a sole proprietorship for which the founders are personally responsible, it is feasible to incur substantial income tax liabilities and legal duties. In the event that an entrepreneur fails to register his or her business with the Internal Revenue Service and create a distinct legal organization for their company, he or she runs the risk of losing their personal assets and, in extreme cases, their homes. While each of the options has its own set of benefits and drawbacks, companies with many owners are more likely to benefit from forming a C corporation rather than a S corporation. Businesses that want to minimize their tax obligations and avoid paying greater expenses during their early phases of growth may want to consider forming a limited liability corporation (LLC). Intellectual property (IP) assignment agreement. If your business wants to expand, an intellectual property assignment agreement may be the most essential legal document you'll ever create. It will determine whether or not your company will be able to get the funding it needs to grow. This is especially true for technology-based companies, since the value of your intellectual property portfolio is usually what investors and venture capital firms look at when evaluating your company's prospects. Among other things, startup founders should record their complete ownership of all intellectual property assets in writing in order to avoid costly claims made by patent trolls and companies trying to copy your business model. It is suggested that during the formation of a new company, the corporation acquires ownership of all significant intellectual property assets. You should be aware that there are 2 types of intellectual property assignment agreements to take into account. In technology assignment agreements (TAAs), any intellectual property created prior to the formation of the firm is transferred to the starting company. Depending on the conditions, developers may opt to keep their own intellectual property ownership rights, or they may choose to sell their rights in exchange for equity or cash. Agreements for invention assignment transfer intellectual property ownership of relevant work product generated by employees following the formation of a new firm to the newly formed company. Typically, the company's founders and employees sign a confidentiality and invention assignment agreement to protect the company's intellectual property. Patents, trademarks, and other intellectual property will be owned entirely by the company. Bylaws. It is essential for business owners to establish strong bylaws from the outset of their venture in order to ensure that their enterprise operates smoothly and with the least amount of problems. Bylaws should outline the internal rules and regulations of a company, including how disputes should be handled, who should be in charge of what, and what rights and privileges shareholders should be entitled to under certain circumstances. Foremost, vote thresholds should be set in the company's bylaws for the approval of certain business actions. Founders Agreement. An operating agreement that is comprehensive should be signed by all co-founders in order to prevent any potential conflicts among the original partners once the company is established. Beyond describing the founders' connection to one another and expressing the assumption that all work would eventually be owned by a single company, an agreement should include a basic communication and dispute resolution provision that, among other things, may aid in the prevention of conflicts from arising. Non-disclosure agreements. The availability of a non-disclosure agreement (NDA) while engaging in commercial discussions with someone outside of your organization is critical. Whenever a prospective employee or investor walks through your door, you must have an NDA agreement available for them to sign as soon as they walk through the door. In addition to safeguarding the ideas of your company's founders and employees, non-disclosure agreements (NDAs) also protect your intellectual property rights. A non-disclosure agreement should contain the following clauses: what exactly is considered sensitive information? What procedures should be followed when dealing with private information? Who is the owner of such information? The company. The time period during which the information will be made public. The secrecy will be maintained for a certain length of time. Employee contracts and offer letters. When hiring new employees, startup CEOs and founders should make certain that their employment contracts and offer letters are simple and clear. This is especially true for new employees who are just starting out. These legal documents are critical in ensuring that employees are aware of the expectations that have been put in front of them. In order for the following to be true, they need make it abundantly clear. The terms and conditions under which employees are employed, e.g., compensation, role responsibilities, working hours and grounds for termination, structure of the reporting chain, ownership of work based on intellectual property, IP, expectations. It is necessary to make some commitments. Company policies governing the vesting of stock options are outlined below, e.g., vacation days, paid time off, structure, dress code. Shareholder agreements. Ultimately, when a business is ready to accept private investments, the CEO should draft a shareholder agreement that defines the rights of shareholders as well as the circumstances under which those rights may be exercised. Some of the rights that shareholders may have include the power to transfer shares, the right of first refusal, redemption in the case of death or incapacity, and the authority to govern and run the business. It is also critical for founders to keep track of any share sales in order to avoid being subjected to substantial financial penalties under state and federal laws and legislation.